you very much for having us this morning. I start with briefly on the issues to do with pre-employment. And by pre-employment, what we mean, they are just those general imposed situations by the law which the employer should comply with. Like in this case, we have the issue to do with the age of employment, as well as the Act, the new amendment on Section 4A, further elaborating on the issue to do with prohibition of forced labor. That is, Section 4A was then amended to allow or permit situations which on the face of it will translate to forced labor. But the Act now provides some of these situations as an exception to the generally held view on forced labor. This is to do with, it adds onto the list issues to do with compulsory military service for work which is purely of military character, as well as any work or service which forms part of the normal civic obligations, as well as any work or service which is exacted on a person as a consequence of their conviction in a court of law, and any work which is exacted by public authority in cases of emergency. So these situations that I've explained to you, although on the face of it, they may appear as forced labor, the law now provides, or rather, they are now an exception. They no longer, by virtue of this amendment, constitute forced labor. Then there is also the issue of employment of people who of minors or children. The new amendment has increased the penalty if one is to be convicted of employing a minor or a child. The level of fine has been increased to level 12, as well as the imprisonment period has increased to 10 years. So it's now critical that we employ people who have attained the legal age of majority, so that we escape from this, the penalty that the lawmaker has imposed on who would be offenders. So still on that, I will move to deal with conditions of service proper, which area may be also critical in the day-to-day running of our employment issues. There are generally, again, 3 changes on rights and obligations. The first relates to the right equal pay between male and their female counterparts employed in same capacities. This has been, the talk that women and men, they should be treated equally. We should not pay men ahead of women. Taking that from gender lines, as well as discriminating women. So there is now a discrete provision, and it should be closed, Section 4 of the Labor Amendment, which says every employer shall pay equal male and female employees for work to which equal value is attributed, without discrimination on grounds of sex or gender. We move also to notice that in the new amendment, there is now a provision that deals with gender-based violence and harassment, as well as violence and harassment. This is a new development. It was not there before. This was meant to take care of employees who might face gender-based violence at the workplace, be it from their employers or their counterparts. So the position of the law is now that when the employee feels that there's been violence and harassment as well as gender-based violence, they can either report that issue to a labor officer or a designated agent as a matter of, or rather as an issue that borders on unfair labor practice. This has now been declared or clearly set out that if one is to perpetrate violence and harassment, gender-based violence, it constitutes unfair labor practice, such that an employee has a right to approach a designated agent or a labor officer and litigate. And also at the same time, we should notice that they also reserve the right to report that matter to the police, and it may lead to prosecution. I also want to deal on the issue of conditions of service. I also want to bring to our attention changes that has been occasioned by the lawmaker on the issue of maternity leave. Maternity leave, on maternity leave, the amendment does away with qualifying service. Remember, back then it used to be that before one can apply for maternity leave, they should have worked for that particular employer for a year. So this has been done away with. There's also a provision, there's also a removal of provision which limits the periods of maternity leave to 3, as well as the intervals of at least 24 months. These issues have been done away with, such that the issue of qualifying service has been removed. The limitation to 3 periods have been removed, as well as the 24-month intervals has been removed. And the next issue that I want to deal with relates to contracts for hourly work. Contracts for hourly work simply refers to a situation where employees will be paid based on the hours that they would have worked but it can only be effective or valid if the same employee on that contract is allowed to take other work elsewhere, as well as the salary that he or she receives in a period of 2 months. 2 months should be equivalent to at least 1 month's salary. 1 month's salary given to their counterparts who are employed on some other contracts, which are not necessarily contracts for hourly work. So these are the key issues, in my view, which employers alike should be aware of. And I'll quickly summarize to say, on the issue of gender-based violence and harassment, these employees now have a discrete right which can be enforced before a labor officer, designated agent, and even in criminal courts. On maternity leave, removal of qualifying periods, intervals, as well as limitations, as well as the introduction of contracts for hourly work. So this would then deal with my presentation on conditions of service.
All right. Thank you very much, Tatenda. So I think what we will do, Tatenda, as I said before, we will now have Pauline's presentation. And then at the end of Pauline's presentation, I will then open the floor for participants to put questions to the two of you.
That's fine, thank you.
All right. Thank you so much, Sarah. So I will now deal with the issue of termination, which I believe regards the employer-employee relationship. So the new Act amends Section 4A of the Labour Act, which amendments I believe has far-reaching consequences as it deals away with termination on notice. Section 12.4A of the previous Labour Act prohibited, in terms of Section 12.4A of the previous Labour Act, the contract could be terminated on notice on 4 grounds. That is in terms of an employment code, through mutual agreement, or where the employee is on fixed-term contract, or pursuant to retrenchment. Now the employer may only terminate through mutual agreement or through disciplinary proceedings where the employee committed conduct that is inconsistent with implied or express provisions of the employment contract in terms of an NEC code or any other applicable employment code. Just note that whilst we are still at those codes, NEC codes must be revised after every 5 years now in terms of the new amendment. Also note that managerial employees are not covered under the NECs. They are dealt with in terms of the national code where there are allegations of disciplinary conduct. So now you can see that we now have limited grounds upon which the employer may terminate. It would also appear that retrenchment was sort of deleted on the new Section 4.4A of the current amendment. However, a reading of Section 12C, subsection 3, shows that the employer still has the right to retrench and must follow the procedure provided under that section for retrenchment. But on the specific grounds which are provided in the new amendment, we only have 2 grounds. That is mutual agreement between the employer and the employee, or through disciplinary proceedings where the employee has committed misconduct. Then I also wish to highlight that the previous Section 12B, which speaks to unfair dismissal, has been retained, and it is still part of our law. It is still applicable. Then in addition to that, the employer can still terminate the contract on common law grounds like repudiation of the contract by an employee. For instance, where an employee takes another job from a different company whilst they are still employed at that company, I think the employer in those circumstances can actually terminate the contract on common law grounds. So in summary, the employer no longer has a unilateral right to terminate on notice. Termination must be in terms of mutual agreement between the employer and the employee, or it has to be pursuant to disciplinary proceedings or retrenchment, or on account of repudiation of the contract by the employee. The employer cannot just wake up and decide to terminate an employee's contract on notice. This is so notwithstanding the fact that Section 12.4 on notice periods have not been repealed. This section, I believe, has effectively been rendered redundant in light of the new section, which limits the grounds on termination to just 2 grounds, which is mutual agreement or disciplinary proceedings. Notice may, however, be necessary for fixed-term contracts on expiry in order to avoid the possibility of a tacit relocation of the employment contract. So, for instance, where the employer is employed an employee on a 1-year contract or 6-month contract, I think it's prudent just to put a clause which speaks to the notice at the end of that, and also to make sure that that is followed up, so that in the event that the employee continues to come to work after expiry of that period, they may not then allege that the contract was tacitly relocated on same terms and conditions. With that, I will now move on to retrenchment. There are quite extensive procedures provided in the new amendment regarding retrenchment, which amends the previous section regarding that. So Section 12C of the Labour Amendment provides for the retrenchment procedure. Under the procedure, there are 3 packages provided in terms of the retrenchment package that the employee can actually get. Section 12C subsection 3 is the starting point as regards retrenchment. It provides that an employer who intends to retrench 1 or more of employees shall give 14 days notice to the retrenchment board, NEC or Works Council, and to the employees involved. So the 3 packages that are provided where the employer intends to retrench the employees are as follows. There is the minimum retrenchment package. That is the 2-week salary for every year served, the one that we had under the Labour Act before the amendment. Then there's an agreed retrenchment package. This one is an agreed amount between the employer and the employee. Then lastly, we have an enhanced retrenchment package. Oh, so this one is at the instance of employees where the employer has proposed the retrenchment package, but the employees feel that the employer has offered a package when they can actually afford more, but they just offered the barest minimum. They can then apply to the board for an enhanced package. Once that application is made, the employer has to respond to the application and is obliged to place audited financial statements before the board. This will enable the board to actually make a decision whether the employer can actually afford more than what the employer is already offered. So the board has to make a decision on the application for enhanced package within 30 days from the date of filing of the application. The package must be paid within 60 days of agreement or retrenchment. Where the board approves an enhanced package, it issues a notification certificate. If the employer does not pay the package, whether it's a minimum package, agreed package, or the enhanced package, the employee can approach the board. The board, if approached regarding non-payment of the retrenchment package, it issues what they call a certificate of non-compliance to the employee. The certificate of non-compliance is deemed by the law to be a liquid document on the basis of which an employee can actually obtain default judgment. Then after obtaining the default judgment, they will have to apply to the Labour Court to get an enforcement order to give effect to that liquid document. Then after obtaining the enforcement order, the employee must register it with the Magistrates Court or the High Court, depending on the value involved and the monetary jurisdiction of these 2 courts. Personally, I believe that the process is quite cumbersome. It's too long because initially you get the retrenchment package. Then if the employer does not pay, you get a certificate of non-compliance, which is said to be a liquid document. But the liquid document itself has to be registered with the Labour Court for enforcement. After that, you then go to the Magistrates Court or the High Court. It's a long process. I think it could have been shorter than that. Then where the employer alleges incapacitation is to pay minimum retrenchment package, they have to apply for exemption to the retrenchment board and provide reasons for that. However, even then, the employer is still obliged to pay at least 25% of the minimum retrenchment package. Please note, however, that any action done in contemplation of retrenchment that diminishes the employer's capacity to pay the minimum package is deemed not to affect the employer's capacity to pay such package. So the reason for not being in a position to pay the minimum retrenchment package must not be as a result of diminished capacity on the part of the employer, which arises from reckless trading or any other grounds that are explained below. So it has to be a valid reason, not to strip the business of assets and then to allege that we are not in a position to pay the employees. So the Act, Section 12cc provides for personal liability for failure to pay retrenchment package, where it can be proved that the failure was as a result of fraudulent, reckless, or gross negligence on the part of the employer, or where the employer is deliberately stripped the asset of the business in contemplation of the retrenchment. For instance, that the employer starts selling major assets of the business 6 months prior to the retrenchment or in a shorter period less than that, with a view to defeating the employee's claim to retrenchment, be considered as diminished capacity, where it can be proved that there has been fraudulent trading, recklessness, or gross negligence on the part of the employer. So where the employees allege that there has been recklessness or fraudulent trading, or that the employer has stripped the business of its assets to defeat the retrenchment payment, the board or the employment council is obliged to give the employer time to respond to the allegations through an affidavit. Where the employer is found liable for fraudulent trading, gross negligence, reckless trading, or where they have stripped the business assets to defeat the employee's claim towards retrenchment, the employer and any person who was a director, owner, or partner of the business, or any other person who knowingly participated in that sort of conduct will be held personally liable without limit for the total minimum retrenchment package on the basis of joint and several liability. So I think with this one, the directors and business owners, senior management should really take note. The persons affected are, however, entitled to an opportunity to be heard to rebut the allegations with satisfactory evidence before the board, before the decision to make them pay is finally made. So this section is quite critical because it extends liability of directors for business decisions. So as I said, the directors, senior officers, management must be on their guard regarding this to see that the business is being properly run and that there are no actions to sort of defeat the employee's claim in the event that they are then retrenched. As regards termination, that is all that I have. Sorry, just a moment. Okay, so I think I had left out the part on dismissal in terms of section 12B. In terms of section 12B of the Labor Act. As I said, this section 12B has not been repealed. It's still part of our law. So it provides for unfair dismissal. I'll go to section 12B3, where it says an employee is deemed to have been unfairly dismissed if the employee if the employer terminated the contract of employment with or without notice. So, sorry, if the employee terminated the contract with or without notice because the employer deliberately made continued employment intolerable for the employees. Then the other one is if on termination of an employment contract of fixed duration, the employee had a legitimate expectation of being re-engaged and another person was engaged instead of the employee. So this is still part of our law, and is one area that on the part of employers, they need to be on their guard. So if the employer makes the employment relationship intolerable and the employee then resigns, the employee can actually raise unfair dismissal. Then the second one is where a fixed term contract expires, then the employee had a legitimate expectation of being re-engaged, but someone else was engaged in their stead. Then the employee can actually prove those things. That constitutes unfair dismissal and is still part of our law. Then, as I said earlier, the registered employment code of conduct should be reviewed every 5 years. The employers must take note of this. There is review of NEC codes every 5 years. Then if such review is not done, the employment code of conduct shall be deemed deregistered. So there will be need to sort of re-register if that is not done in every 5 years. That is all from me. I will back to you, Sarah.
All right, thank you very much, Pauline. In fact, I noticed in the chat group, on the chat platform, that they are you are being complimented for the presentations. Sitle Liwayo says, great session and very informative. Kindly advise how we will get the recording as well. And then Oti also says, yes, please, we will need the recording. So yeah, so some very positive compliments there. All right, so yes, so that was the formal presentation by Tatenda and Pauline. Does the audience have any questions for our two panelists, our two speakers?
Sorry, Sarah, maybe just to take you back a bit, we had sort of 5 areas that we wanted to touch on. So we are now left with collective labor law and dispute resolution. I'm not sure whether this will be dealt with after the question and answer session. Thank you.
No, that's fine. So is that Tatenda now? Are we going back to Tatenda? All right.
Yes.
And then after his presentation, we have the question and answer, is it?
Yes.
All right.
Okay, thank you, Sarah.
Okay.
Thank you, ladies and gentlemen. This one is a short presentation. I will do first with collective labor law. On this one, we are looking at the registration of employer organizations, trade unions in the case of employees, as well as NEC and National Employment Councils and deliberations thereat which are envisaged by the law. So I want you just to take note, there are changes which are there, like in terms of negotiations, which at the National Employment Council, which will affect a parastatal. The law now says the minister responsible for that parastatal, which will be so affected, should be made part of those deliberations. And there is now an increased scope of what can be negotiated at the National Employment Council as well as the Workers' Committee level to include educational leave. And there are also issues to do with variations, rescission, as well as suspension of trade unions and employer organizations. The issue to do with registrations of CBAs, it remains intact, and there are no material changes. So these points, while they do not deal with the day-to-day activities at the workplace, they are critical in the sense that the employers are then made aware of what is happening in those forums which have the capacity to deal with issues that affect the day-to-day activities in the workplace. So with that said, I will quickly move on to the issue of collective job actions by the employees. There isn't much rather than, I just noticed an increased, penalty for those employees which are employed in the essential service. I'm sure this is a deterrence measure such that in the event that they are found guilty of either inciting or attempting to incite an unlawful job action, they will be liable to a fine which does not exceed level 14 and 5 years in the case of employees employed in the essential service, as well as those who are not, they will only be liable to level 14 fine and a 1 year imprisonment period. Also, I'll turn to the issue of dispute resolution. The workplace is characterized, our interests, the employer's interest and employees' interest sometimes may clash such that there will be need to find a resolution in the event that a dispute emanates. So I'll quickly take you back. Back then, employees, this area is mainly dominated by employees. If they were not happy, they had the option of approaching a labor officer who will, after issuing a certificate of no settlement, was obliged by the law to write what we called a draft ruling, which will then be subjected to confirmation proceedings at the labor court. This is now a thing of the past. Labor officers are now, in terms of the Labor Amendment Act, obliged to write final and definitive rulings, which may be taken on appeal to the labor court. And I also want you to notice the fact that in the event that an employee chooses to submit their case to a designated agent, back then the designated agents did not have a cap in terms of the period within which they are expected to have dealt with the issue submitted before them. So the new law now proposes a 30-day period from the day of referral. They should have dealt with that matter, failing which an employee or an employer, whoever is aggrieved, he has the option to take that matter to a labor officer. I'm sure we are all aware of the difference between a designated agent as well as a labor officer. It's just simple in that a designated agent is employed by the National Employment Council, and it deals with those employees who are subject to the jurisdiction of that National Employment Council. And you'll be aware of the fact that managerial employees are not then part of those those employees whose conditions of service are regulated by the National Employment Council. Quite often they refer their matter or disputes to a labor officer. A labor officer is a public servant employed by the Ministry of Labor. So in the event that when the labor officer or a designated agent, after issuing a certificate of no settlement, they also have the option of referring the matter to compulsory arbitration. Compulsory arbitration, and in the past or just recently, that issue was no longer there, and that's when we had most of the labor officers writing draft rulings. So now the issues can be referred to compulsory arbitration, where parties can submit themselves to an arbitrator who is chosen in terms of the Labor Act, or this may be guided by the Arbitration Act. And just to make a correction, where I said earlier on that a labor officer can make a final and definitive ruling. it is a designated agent who has, so we can substitute that with a designated agent, not a labor officer. A labor officer, they issue a certificate of settlement. When they issue a certificate of settlement, it can be registered either in the High Court or the Magistrate Court, and it takes the form of the order of that court. And when they issue a certificate of no settlement, they then have to refer the matter to arbitration. So that will be all on collective labor law as well as dispute resolution.
All right. Thank you, Tatenda, for the conclusion of that area of your presentation. All right. So, ladies and gentlemen, you've all heard the submissions that have been made by Tatenda and Pauline. This is now your opportunity to put a question to them for clarification of any matters that you feel have not been spoken clearly, or where perhaps you have some confusion as to what is the meaning of what they have presented to us.
Thank you. I've got a question for, was it Pauline who made the second presentation?
Yes, it was Pauline.
Yes. She mentioned the minimum package, which of 2 weeks pay for every year served, which I believe was contained in a section that was repealed. And I know that the amended act refers to a minimum package, but there are no numbers. Are we to assume that that minimum package is still 2 weeks for every year served? I will tell you that we approached the retrenchment board and they advised that at the moment they are not accepting any retrenchment notifications because there is a problem with the minimum package. It's not specified.
Sorry, thank you, Aldo. Pauline, would you like to respond to that?
Hello, thank you for the question. Might I get back on that a bit later? We can have the other questions, then we can address them at the end.
All right, that's fine. So
Okay.
perhaps if, all right, so Aldo shall come back to you.
That's fine. I've got a second question for her as well. Yes, she did say that terminations are only on 2 grounds, by mutual agreement or pursuant to a disciplinary action. But in the section that talks of a disciplinary action, it also says, or in any other manner agreed in advance by the employer and the employee. Is that manner simply confined to disciplinary cases?
Thank you for the question. Might you come back again on the last question? Sorry, I didn't fully get it.
Right. The last question, you said, you know, termination of employment of contracts is now on 2 grounds, isn't it?
Yes.
First is by mutual agreement between the parties. And the second is pursuant to disciplinary proceedings.
Yes.
But when you read that section that talks of disciplinary proceedings, it also says, or in any other manner agreed in advance by the employer and the employee. I need for you to explain that. What is it? What is that referring to?
Oh, okay. Thank you for the question, Mr. Semburi. Let me just go to the amendment to that part. So it says a contract of employment may be terminated only on the part of an employee by his or her resignation or retirement, and in the following cases on the part of the employer: A, by mutual agreement in writing; B, for breach of an express or implied term of contract, upon such breach being verified after due inquiry under an applicable employment code, or in any other manner agreed in advance by the employer and the employee consent. So
Yes,
the last part,
bit.
Yes. So you're asking on the last part, which says in any other manner agreed in advance.
Yes.
Okay, my reading of section B is that there has to be disciplinary proceedings either in terms of an applicable code, or maybe any other, if there's a policy or whatever that the employer and the employee agreed upon, that any dispute will be dealt with in terms of that. So that sort of document that regulates that aspect of the relationship.
So if that is the case, if it's a policy that would simply have been laid down by the employer, isn't it?
Yes.
And if it's a policy laid out by the employer, you would say that had been agreed in advance between the employer and the employee.
Sorry, can you come again?
Would that be deemed to have been agreed between the employer and the employee? Because policies are unilaterally laid out by the employer.
But I guess when the employee signs the contract of employment, you are referred to the documents that governs that kind of relationship. I understand what you are saying. It's sort of one-sided, but I think the intention of the legislature in this section is that there has to be disciplinary proceedings, either in terms of a court or any other manner agreed. That could be a policy, that could be an internal document. But I guess when you sign the contract, there's discussion between the employer and the employee, and there's reference also to all the guiding documents that regulates the relationship between the employer and the employee. That's my understanding of that part. I wouldn't want to believe that it gives the employer a third ground to dismiss an employee outside those two. I don't think the courts will agree to that.
Okay, I'll take note of what you have said.
Tatenda can add on that, Mr. Msembwe.
Yeah, that's fine.
Thank you, Mr. Msemburi, for that observation. I would want to make just a brief submission on that, to say, like what my colleague has just said, that the reference to in any other manner agreed in advance will not open up for other grounds of termination other than those stated. You would notice from that provision that the separation between an applicable employment code as well as in any other manner agreed is the use of the word or, meaning that the context cannot be different. The context should always be the same if you are to go by what the use of or means. So I would still say it doesn't give other options. The options are still limited to the context envisaged in that paragraph B. That would be all.
Okay.
All right, thank you, Tatenda. Pauline, do you have an answer now for Mr. Musemburi's first question about the minimum retrenchment package?
Thank you, Sarah. Not yet. I'm just trying to verify with the Act in the meantime. We could have other questions from the floor, then I can attend to that much later. Thank you.
No, that's fine. So perhaps I can then ask Gloria.
Sorry. Perhaps Pauline can also, you will notice that I think in the amendments, it talks of time within which a retrenchment package needs to be paid, isn't it? But it looks like there's an omission somewhere. It doesn't specify, does it?
Indeed. Thank you for that, Mr. Msemburi. It's actually, I noticed that in the bill, when they passed the bill, they had 60 days, but in the actual amendment, they omitted that part.
Yes.
Yeah, I think it was sort of rushed. Thank you for that.
Okay, thank you as well. That will be all from me.
Actually, I have checked on your first question, the minimum retrenchment package is not defined actually.
Yes.
So that should be an omission again on the part of the legislature, which will need to be rectified as soon as possible.
Okay.
Yeah, thank you so much for your question.
All right, Pauline, and maybe just following up briefly on that issue of if there's no period for within which retrenchment package is to be paid, do you see that as also being a provision that will need to be rectified? Because otherwise, how do employees allege that there has been non-payment?
Indeed, because now if we do not have sort of a period within which the amount has to be paid, I think you can't approach the board to say that they failed to pay within what? It has to be paid within a reasonable period in terms of the common law. And that reasonable period, reasonable is quite liquid. So that's a problem that needs to be rectified as soon as possible.
All right. Thank you,
What you
Pauline.
may need to do, Pauline, is just to inquire from the retrenchment board, because the understanding is that they seem to be proposing a statutory instrument to address that. I don't know whether that will be accepted.
All right. Thank you for that. Those interventions, Mr. Musemburu. So I'll now turn to Gloria Bususu. Gloria?
Thank you, Sarah. My question is on termination. You mentioned that, I think it's Pauline, she mentioned something to do with terminating a contract. Let's say someone has a 1-year contract and the contract is expiring, say, end of December. I picked from what she was saying that the employee does not have a sole right to terminate this contract. It might be deemed unfair dismissal. I didn't quite get that.
Right.
Thank you.
Sorry, I didn't quite get how it can then be an unfair dismissal when the contract is ended, is expired, rather.
Thank you for your question, Gloria. So let me take you back to section 12B. So we said in terms of that section, it's deemed to be unfair dismissal where it's a fixed term contract and the employer, the contract is expired, but the employee had a legitimate expectation of re-engagement, but the employer also engaged someone else after the expiry. So we have a fixed term contract, let's say, which expires after a year. Then at the end of the year, the employer notifies the employee that we are not renewing the contract, but the employee has a legitimate expectation of being re-engaged, and someone else is engaged in their stead. So that's the scenario where then the court says dismissal was unfair. There has to be legitimate expectation of re-engagement, and the employer would have employed someone instead of the employee whose contract is terminated. So there are situations, I'll give an example. Let's say someone is a 1-year contract, and in the contract, we do not insert a clause which says at the expiry of 1 year, the employee should not have any expectation of re-engagement. Then in performance appraisals, let's say the employer comes and say, you're doing very well. We will consider, or we may renew your contract, something like that. Maybe it's in writing or it's not. Then such conduct on the part of the employer then makes the employee to believe that on expiry of my 1 year, I think I have a chance of being re-engaged here. Then at the end of that 1 year, the employer then engages someone else instead of that employee. The employee can actually approach the courts alleging unfair dismissal in those circumstances. So what I've always advised clients that in fixed term contracts, the best thing to do is that you insert a clause which says that this is a contract for 1 year commencing on this date, ending on this date. There shall be no legitimate expectation of re-engagement at the end of that period. Then you leave it like that. That way, even if the employee then says, I was expecting to be re-engaged, it would be in black and white in the contract that there shouldn't be any legitimate expectation of re-engagement. I hope you are answered.
All right, thank you. So we are we saying and or is it or? Like to say legitimate, there should be legitimate expectation or re-engagement, or we are saying legitimate expectation and engagement of another person for that contract. What I'm saying is, let's say that contract has been terminated and there was legitimate expectation, but at the same time, there was no one was then recruited to the same position. So do we need to have all the legitimate and engagement of another person, or it's either it can be unfair dismissal when you either employ another person for the same position or there is legitimate expectation, or those two should apply together for it to be unfair dismissal?
Thank you for that, Gloria. So the Act actually uses the word and, meaning the employee should actually prove and claim that I had a legitimate expectation of being re-engaged and so was engaged instead of me. So both the requirements should be satisfied before the court can actually conclude that it's unfair dismissal at the end of a fixed term contract. If you just allege that I had a legitimate of expectation and the position was not filled in, or no one was employed in your state, then you can't succeed in a claim of that sort.
Okay, thank you. And then what is the required notice period for termination? Let's say someone had a 1-year contract.
So the periods, the notice periods for termination, they differ with the duration. I think for a 1-year contract, it should be a month. Let me just cross-check in the Act. It's provided in terms of Section 4 of the Act. It should be a month.
Okay.
Yes.
Yeah, all right. That should be all from my side. Thank you.
You're welcome.
Thank you, Gloria. Any other questions for our speakers? Pauline or Tate? Oh, sorry. Okay, we've got a question from Faith. Faith Mkahiwa.
Faith, you may go ahead.
Faith, can you hear us? All right, it looks as though Faith may have problems with the audio. Lisa, we've got Lisa. You may ask your question.
Okay, thank you so much. My question is on termination of permanent contracts. Since it has been stated that we can only terminate through mutual agreement or through a disciplinary hearing, I want to confirm the notice period that we will use after mutually agreeing with an employee that we are terminating his or her permanent contract. I want to confirm the notice period that we use when calculating the packages. Do we still use the 3 months, or is now a mutual agreement that we say we now calculating using the 1 month notice? Or do we still stick to the 3 months, which is stated in Section 4? Thank you.
Thank you, Lisa, for the question. So we are saying the employer and the employee have agreed to mutual separation, right? Hello, Lisa?
Yes.
Okay, so in that case, I do not think we are bound. Ordinarily, for a permanent employment contract is 3 months notice. But where the
Okay.
parties have agreed to mutually separate, they would have to sort of have an agreement regarding the terms of the mutual separation. So the notice period regarding that can actually be agreed between the parties.
Okay, okay, thank you.
All right.
Hello, Faith. Your hand is still up. Since you don't have audio, are you able to type your question?
Yes,
In
can
the
you hear me
chat?
now?
Yes, we can hear
Yes.
you now.
Okay, I wanted to ask on the issue of legitimate expectation and then employing someone else in that person's stead. Is there a required period that is required to lapse before we can employ someone else if someone's contract is not renewed?
Thank you, Faith. So the Act and the law does not provide sort of a period regarding that.
All right, thank you.
Yeah, so there's no period that's mentioned in the law. But just for information, labor disputes, let's say if you are alleging unfair dismissal, I think you have to institute your claim within 2 years. So if the employer, let's say they wait until that period is expired and all that, it's now an issue to do with prescription of that claim.
Oh, okay. So if within 2 years someone is employed, then that employee has a right to say someone else was employed in my stead. But maybe after 2 years, then we can say that issue is lapsed.
Yeah, I think so. I think it would have lapsed.
All right, thank you.
Okay.
Pauline, so maybe just to clarify, are you saying that an employee can, the employer cannot employ somebody within a period of 2 years without there being an allegation of a complaint by the employee whose contract was terminated? Or it is that the employee whose contract was terminated has a period within 2 years within which to come back to the employer and say that I was unfairly dismissed when I expected to be reinstated or to have my contract renewed for that particular position.
Thank you, Sarah. So what we are saying is that the employee, if they are alleging unfair dismissal, they have to make sure that they prosecute their claim within 2 years from the date of dismissal. So the Act does not sort of provide a period within which you can allege that someone was then engaged after this period. But I was just saying, now that we have that sort of prescription period, the employee must action their claim within 2 years from dismissal.
All right, thank you.
I hope that's clear. All right.
Do we have any other questions for our speakers? I was going to ask Tatenda on the issue of the employment of young persons. You indicated that the Act has now increased the criminal penalties. I think you said that the term of imprisonment is now up to 10 years. And I think the fine, I think you said was level 10, which I think is around $700. Are you aware of why the criminal penalties have been increased to such a great extent?
Thank you, Mrs. Moyo. Maybe I just want to refer to the answered, maybe briefly. in just a minute or so. If we can, maybe if there's another question, we can take that one as I.
All right, and then perhaps whilst we are waiting for your answer, Pauline, with respect to employees who are on fixed term contracts, does the amendment make any provision as to the number of times employees can be hired on short-term contracts without becoming permanent employee before they become permanent employees? Because I think in the last few years, there has been a tendency by industry sometimes to hire employees on fixed term contracts and simply continually renew, whether it's a year's contract or a 6-month contract. Is there any provision about that in the Labour Amendment Act?
Thank you, Sarah. So the final act does not speak to that, but in the proposed bill, there were provisions regarding that, but they didn't make it through to the final draft. So there's nothing that speaks to those periods. But I know that with the NEC for the commercial industries, there's a maximum of about 6 times.
All right, okay, that's fine. And then the other question I was going to put to you, Pauline, with regard to the amendments, which now provide for gender-based violence or sexual harassment now to be acts of unfair labor practice. In the media, we've had reports of employers who have been charged with sexual harassment as in the criminal courts, but then have been acquitted of those charges. In that situation, if the employer had commenced, let's say, disciplinary proceedings within the workplace, and the disciplinary panel, the internal disciplinary panel, came to the conclusion that there was indeed sexual harassment, would that employee who has been, would that employer who has been acquitted have a right to demand reinstatement? What does the Labour Amendment Act say about that?
Sorry, Sarah, I didn't get the last part regarding reinstatement. Might you come again on that?
Yes, so I said where there has been an allegation of sexual harassment or gender-based violence in the workplace, and the offending employee has been found guilty under the internal disciplinary proceedings in the workplace, but at the same time acquitted in the criminal courts of that allegation of misconduct. Would that employee then have a right to demand reinstatement where he was acquitted of the criminal charge, but found guilty under the internal processes of the workplace?
Oh, okay. Thank you for that. I think these are the criminal side and the labor side of things are two things that can run separately. But all the same, if we are saying someone has been acquitted in the criminal proceedings, but found guilty in the labor disciplinary proceedings, I think it's now an issue to do with burden that has to be discharged by the state and also by the internal disciplinary committee. With criminal proceedings, the burden is quite high because it's beyond any reasonable doubt. Whereas with disciplinary proceedings, I think it's on a balance of probabilities. So I don't think that the employee can then come back and say, I should be reinstated, because these are two separate processes. That's what I think.
All right. Thank you, Pauline.
You're welcome.
Any other questions for our speakers?
Hello, Sarah. I was raising my.
Sorry, I think I've moved to is that Faith?
Yes.
Okay, sorry, oh, Faith. Okay, yes, Faith, you can put your question.
All right. I had written it in the chat, but I wanted to ask that if there's a clause in a fixed term contract that says that there shall be no legitimate expectation of renewal or reappointment, is there need then, okay, and then the statement goes on to say, therefore, the contract automatically lapses on and gives a date. Is there need to then give notice when that date approaches, when the contract is supposed to end?
Thank you for that, Faith. I think in those circumstances, there is no need to give notice, because the parties would have already agreed in their contracts that the contract automatically terminates. So to then give notice, it's not necessary unless the employer just wants to give notice.
Okay, thank you.
All right. Maybe just to get back to Gloria regarding the notice period for a 1-year contract, it's actually a month. Hello.
Hello, Pauline.
I wanted to say, with regards to your question earlier, on the notice period in respect of a 1-year contract, it's 1 month in terms of the Act.
All right, thank you. I also had another question. I don't know if I may go ahead. I was raising my hand.
Yes, you may proceed with your question. Hello?
Hello?
Yes, Gloria.
Okay. I wanted to ask, we have a scenario that we have not been presented here, but I thought maybe since we have this platform, I could just ask. So we have an employee who has been working under a 1-year contract, and then he reported in sick, and then he said by word of mouth that I've been given a month by the doctor to a 1 month sick leave. And then we asked for the sick leave, like the doctor's note, and he did not provide, and he did not even sign the leave forms. And then after a month, he then sent a WhatsApp message to say, I don't think I'll be coming back to work because I have a condition that do not allow me to be working, a health condition. So that's how this employee just left work. They did not resign. They did not sign any leave form. They did not bring in any doctor's note. But after our investigations, we figured for sure this person is actually sick, and he's got a medical condition for sure. So I don't know how do we proceed with that, because he's not coming to work, he's no longer getting paid, but there is no any formal termination or formal communication. It's just a matter of seeking for advice.
Thank you, Gloria. So with that, I think with resignation, it could be in writing, it could be verbal. I understand the underlying reasoning behind here advising that I will not be coming to work. I'm unable to do that. But to me, I think that's resignation. However, I think we can discuss. Do you mind if we discuss after this regarding that issue?
Yes, that's okay.
All right. You can get my number from Melody.
Okay, Melody or from certain CC.
Yes.
Yeah.
All right. Thank you, Pauline. Any other questions for our speakers?
Maybe maybe I
hello.
can come in, Mrs. Moyo, in response to the question that you had raised.
Mm-hmm.
Okay. The rationale behind that deterrent penalty, it appears in the initial bill that the lawmaker wanted to curb child labor in order to avoid what they termed increasing trading sanctions on goods produced in child labor prone markets. So they thought if they tighten the screws, for the employers, this is the first step, which will then assist them in that regard. But secondly, which view is not also captured in the bill, there has been a deliberate decision to protect minor children. There's been a deliberate view held by almost everyone to saying they are vulnerable. And as you might have seen, and as you might have also followed from some sections of media, it's not only in the employment sector, but also in the area of child marriages and so forth and so forth. So my response to you is a two-pronged. The one answer that appears in the clause to say they wanted to curb or wanted to put separate measures against imminent increase in trade sanctions, which may be imposed in child labor prone markets. And number two, there is also a deliberate decision and a deliberate direction to ensure that children, being vulnerable members of the society, are protected.
Thank you, Tatenda. And then maybe one more question from me. Tatenda, I just wanted you to clarify the issue of contracts for hourly work. You indicated that where one hires an employee for hourly work, in the sense that they are only paid for the actual hours that they work, that they are entitled, that the contract of employment must then allow them to find other work so that they can supplement their pay. But you also indicated that there's a provision in terms of which the employer who is offering the hourly pay or hourly work must have a minimum amount that he must pay that employee. Can you just clarify that, because it wasn't very clear? And also, who is considered to, who has the obligation to pay that minimum wage? Let's say where somebody is contracted to two employers. So you have so where a person is working for, let's say, two different companies, each hiring them on an hourly basis. What does the amendment to the Labor Act mean in those circumstances? What are the obligations of each employer who is hiring that individual on an hourly basis?
Well, thank you, Mrs. Moyo. I check your question to be in two parts. Firstly, for me to clarify the meaning of that, I think the obligations of each and every employer in the event that the employee is employed by more than one employer. You know, my reading of that provision, we deal first with the employer as the employee. I mean, we do not take at that stage into account the other options which the employee might have to take another employment. We are confined to the employment contract which has been signed by the employee and the employer. There's no room under that provision to, like, let's say, consider what other rights and obligations which the employee might have under other, some other employment setups. It remains an employee's option, and they will enforce that as and when the need arises. So I would argue to say is that employee whose contract of employment is under scrutiny or some enforcement is being sought. There's no provision for taking into account what could be other options or what could be other engagements by the employee. So then secondly, on the issue of payment, I'd say that for that contract of hourly work to be valid, there are some conditions which are imposed by the lawmaker. The first condition is that the employee should be allowed to take some other work elsewhere. Then the second condition is that at the end of the 2 months period, if the employee is to be employed consecutively, his or her total salary should not be less than a month's salary for any, compared to their counterpart who are not employed under a contract of hourly work. This rider, I would argue to say, it's a deliberate position by the lawmaker to curb what could be possibly, exploitation in the circumstances for those employees who are on hourly contracts. It's just there to ensure that they are treated at the same time they're exposed to decent working conditions, which include at least a decent salary and a decent pay. I don't know if I've managed to respond to that. And actually, the other third condition is that employers and employees, they can decide through the NEC forum to say, no, in our sector, we do not want these hourly contracts. And once there is that provision in a CBA, it becomes unlawful if you are to implement such type of employment contracts. I do not know, Mrs. Moyo, if I've responded you correctly.
Yes, no, you have answered me, Tatenda, and I think that's also useful information to know that NECs can actually negotiate against having hourly contracts in a specific sector. I think that's useful information to know, so that obviously our members would then be able to check before they sign these hourly contracts.
Thank you.
All right. Okay. My watch is saying 10:28, and we had scheduled to have this meeting up to 10:30. Are there any other burning issues that people would like to raise with the speakers before we formally close the meeting? Gloria, I don't know if that's an old hand.
Yes, that's an old hand.
All right. Anybody else in the meeting would like to put a question to our speakers? Perhaps whilst we are waiting for a final question, I wanted to ask Melody as Secretariat. There have been quite a few requests in the chat in the chat platform for the recordings to be circulated to attendees. Will that be possible? I assume that our speakers will have no objection to the recording being circulated, to their presentations being circulated.
Yes,
No
Mrs. Moyo, that's
objection
very
to that, Sarah.
Thank you very much, Pauline. And Melody, you said that will be possible.
yes, that will be possible, Mrs. Moyo. We'll
All right.
send as
No.
soon as we receive from Pauline.
All right. Okay. No, thank you very much. So I think then it just takes for me to say thank you very much to our speakers, Pauline and Tatenda, who are both lawyers at Winterton's Legal Practitioners. Thank you very much for taking the time to make this very informative presentation to members of ZNCC as well as non-members. As I said before, there have been lots of compliments on your presentation, which has been found to be very informative and very useful for our members who are employers in the business sector. And I would also like to appreciate ZNCC Secretariat for taking the time to host this important meeting. As I said, this is a resumption of a series of business meetings which had been suspended during the COVID-19 pandemic. And I think that you will all agree with me that the Secretariat has done a good thing in resuming these business sessions, which have been very informative. In fact, I've seen on the list of participants that we have had as many as 61 participants. Some attendees have been dropping off as they have had to go to other engagements. So this has definitely been a very successful meeting. So thank you all for taking the time out of your busy programs to attend this meeting, which I think is a vote of confidence for the Secretariat to continue these meetings. So thank you very much. I hope you enjoy the rest of your day. Thank you. Bye.